Hey, and welcome to the video, The Advanced Guide to Selecting Co-Trustees. So I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. I get my video content from a lot of different places, almost 3 decades of experience. Day-to-day issues come up, but this one comes from a comment that Brandon wrote in response to one of my other videos. And so when I see a good question that I think would be appropriate for a video, make a video out of it. So thanks for the question, Brandon. Keep them coming. Brandon writes in a comment, "Hello, Paul. Love your videos!" Exclamation point. How about a discussion on when to consider using co-trustees and different ways to arrange their relationship with each other? All right, so I started thinking about that, and I thought a little more, and so let's just dive into the topic and cover it for maybe 7 or 8 minutes. But before I do that, let me remind you, every day, educational estate planning video published here on YouTube, 10 a.m. Central Time, every day, check in. Also, if you haven't already subscribed, hit the subscribe button with the notification bell. If you have already subscribed, thank you. And then if you feel like giving the video a thumbs up and posting any comments like Brandon, feel free to do that. And I tend to look at most, if not all, of the comments. Okay, so for purposes of this discussion, I'm going to talk about really 2 different kinds of trustees. I'm going to talk about, in one sense, the temporary trustee. I'll come back to that. And then I'm going to talk about the trustee or co-trustees that will last for years, if not decades. So first I want to go over that temporary position of trustee, and then we'll go into the one that's a little more juicy, the one that's going to last for a long time. But the temporary one is so common, I got to bring it up. And I may refer to trustee and co-trustees and all of that in different terms, so just bear with me on there. So let me give an example. Earl and Gladys, this is the temporary trustee part. Earl and Gladys set up their revocable living trust. Let's just say Earl and Gladys had 4 kids, they had 9 grandkids, and they're leaving their estate or their trust, or at least they want to. They want to, leave everything to the 4 children equally. Very common. Now, when they set up their revocable living trust, and again, they're setting it up because they don't want to leave everything in their name, requiring the court-supervised probate when they die. They want to have things titled in their trust to make it easier for the distributions to be made when they die outside of court and attorney involvement. A lot more on that in other videos. But when they set up their revocable living trust, they have to name a trustee or co-trustees to handle things when they die. Sometimes people ask me, Paul, can't we just say it goes to the 4 kids equally and we don't have to name a trustee? And I'm like, nope, you got to name a trustee whose job it is to make sure it goes to the 4 kids equally. So then they're like, Paul, what is your suggestion? Who should we name? And then my response is always, well, let's talk about what the role of that trustee or co-trustees would be. And then maybe you can tell me who you think would be most appropriate to be that trustee or co-trustee. So every family is unique. Every family, every couple, every individual owns different things, has, different children and grandchildren. But in general, when a couple sets up a revocable living trust and they both pass away, that trust becomes irrevocable. And in the trust instrument, there's a trustee or co-trustees named. Their job typically, again, can vary based on what assets exist. But in a typical mom and pop with kids scenario, that successor trustee or co-trustees perhaps will sell the family home, will initiate contact with the financial institutions, the banks, the brokerage firms. So that successor trustee or co-trustee is the one who's responsible for making sure that the assets are distributed to the principal beneficiaries that are listed in the trust instrument. So who should be that trustee or successor co-trustees? Let me give you a couple of rules, then we'll go into some of the dynamics. So, sometimes there's just one, even though there's 4 principal beneficiaries of a revocable living trust, there's only one trustee named. So that's common when the parents say, we got this one child, he'd be perfect for the job. He's fair. He's got a great relationship with all of his siblings. He's organized. Oh, by the way, he's an accountant. He understands all that stuff. He's very frugal, and so he's the one. But sometimes parents say, I want to designate 2 or more co-trustees to be the successor co-trustees of our revocable living trust. Let me give you some law real quick. This is the Louisiana Trust Code version. If you're not in Louisiana, you're going to need to check with your state. But this is the 2 or more co-trustees. So our Louisiana Trust Code says if there are 2 trustees, the powers conferred upon them shall be exercised only by both of them. So if Earl and Gladys had 4 kids, name 2 of those kids as the co-trustees, and the co-trustee, 1 or both of them, determine that it's appropriate to sell the house after Earl and Gladys die so they can divide up the house sale proceeds 4 ways equally. It's going to take both of those co-trustees to put the house up for sale, sell the house, go to the closing and all that. So two co-trustees, they both got to act together. Now, the trust instrument could say something different, such as either one of them can act as a trustee if I name 2 or more co-trustees. Now, if there's 3 or more co-trustees, there's a different provision for that. A power vested in 3 or more trustees may be exercised by a majority of the trustees unless the trust instrument provides otherwise. Okay, so if you got 3 co-trustees and you don't provide otherwise, 2 out of the 3 can act. So really, if it could come down to kind of a 2 versus 1 scenario with the 1 being outnumbered on everything. So you could say that if you were designating 3 co-trustees, they all had to act to take action, but in absence of that, a majority can do things when there's 3 or more co-trustees. All right, that's just all the legal mumbo jumbo. In terms of this temporary trust, where because the co-trustees or trustee, their role is not going to last very long in that revocable living trust scenario when the parents die, typically. Their role may last a matter of days or weeks or months, depending upon the assets that the successor trustee or co-trustees have to deal with. And in that temporary trustee position, there's not a whole lot of discretion that gets exercised by the trustee or co-trustees. They're just wrapping things up and getting it to those principal beneficiaries as fast as they can. Maybe some of the discretion that those co-trustees in a temporary position, some of the discretion that they get involved in are things like, should we sell the house or should we just transfer it to the 4 kids so that the 4 kids co-own it and the 4 kids can deal with it later? Other discretionary decisions, mom and dad, Earl and Gladys, had 100 shares of stock. Should we sell the stock and just divide up the money 4 ways, or should we make sure each child gets 25 shares of stock? So those are some of those decisions that in that temporary termination of a revocable living trust arrangement, those are the decisions co-trustees have. I will tell you, in a practical matter, sometimes it seems like typically it's the mother who gets kind of caught up in not wanting to offend a child, and so they worry more about that decision than maybe how much is left or how things are left to the family. They worry about that trustee. They don't want to offend other children. So when I see it worries them so much, I'm like, well, maybe you should go, talk to your children about that and get feedback from them, and then you can make a decision based on the feedback that you get from your children. And sometimes they do that. And then, Earl and Gladys come back, and I say, did you talk to your children? And Gladys will say, yeah, I worried about it, for weeks. Finally, we got together at Thanksgiving, and I asked them all. Gladys will say, we've been talking to a lawyer, and this is her conversation with her kids. And the lawyer said we had to pick, 1 or more of you to be the trustees. I don't know what to do. And then I'll say, well, what did your children tell you? And in most circumstances, the children will tell Earl and Gladys, we don't care. Do whatever you want to. And I will tell you what many of the children are thinking is something like, we don't care who the trustee is, as long as I get my 1/4 share. Heck, Flavor Flav can be the trustee, But so I don't care who you name as the trustee, name me, name my sibling, name co-trustees, name somebody else. But as long as I get my 1/4, I'm happy. In fact, a lot of the kids are thinking, and if I can get my 1/4 without having to do anything, without having to go through the trouble of dealing with all of your financial institutions and selling your house and dealing with all that, even better. So it's just kind of funny to see how the parents worry about it and kind of what's in their mind and then what's in the minds of those children or those beneficiaries or those people who will inherit. Okay, so that's it for that temporary trustee position. Hope that helps. Now let's go on to one that's a little more juicy, that long-term trustee or co-trustee position. And there's a gazillion different arrangements where, trusts last for a very long time. But let's change the situation from Earl and Gladys a little bit. Let's say Earl and Gladys have 4 children, but one of those children, Earl and Gladys, it doesn't feel right to Earl and Gladys that they dump a bunch of money one day into that child's lap. And it could be for a number of reasons. Maybe the child just has a long history of not being able to handle money. Maybe every time that child gets a nickel, he spends a quarter. Maybe the child has a drug issue. And so whether it's opioids or whatever, the parents know it's not a good idea to just dump money in that child's lap. Maybe the child has a spouse who is so controlling and influential over their child that if the child gets money, even though it's the child's money, that spouse will exert so much influence that the money will be gone because it'll go to wherever the spouse wants it to go. So under those circumstances, that's just one of many issues where a parent may say, well, these 3 kids, they're fine, they can have their money. But as to this one child, we want to make sure that after we pass away, it goes in trust for that child and under certain terms. And now Earl and Gladys have to name a trustee or co-trustees who will manage that money on behalf of that child and dole it out under certain situations. So now we need to take a close look at the relationship between the trustee or co-trustees of the trust for that child and the beneficiary or that child, because now in that long-term trust, those trustees are likely to be exercising some discretion. And so from year to year, as the years go on, those trustees, depending upon the terms of the trust, will often have to exercise discretion. And so those trustees will have to perhaps make a decision regularly, something like, okay, my brother, he's saying he needs some money for rent. He's saying he needs some money for a car. He's saying he needs some money for medicine. And in that trust, it says I or we, us trustee or trustees, have the discretion to give our brother money for his health, for his education, for his maintenance, for his support. So under these circumstances, do I feel it's right to exercise my discretion and give my brother money or spend money on behalf of my brother from his trust? So that one can get tricky, because you may have a beneficiary who's imposing some heat or some pressure on their trustee or co-trustee siblings, saying, hey, look, I really need the money, please give it to me. And so there's a lot of dynamics there to be involved. So I feel like that is the situation, that long-term trustee relationship, where you really have to think hard and get informed before you designate whether you should have 1 trustee or 2 or more co-trustees. The argument for having 2 or more co-trustees in that arrangement is you don't have just one bad guy. That beneficiary has to convince both co-trustees, particularly if you're here in Louisiana or in a state where 2 trustees must act together on all trust matters, then perhaps it is a good idea to designate 2 or more co-trustees of that trust. And since it is going to last perhaps for the beneficiary's lifetime, you should have alternates in place. I designate child 1 and child 2 to be the co-trustees. If either one of them can't do it, child 3 will be a co-trustee, and this trust is in place for child 4. May even state if there is a vacancy in that co-trustee position, then that sole remaining trustee can appoint another co-trustee. So something like that. So because discretion is going to be exercised over a number of years, and so that's where you have to look at the dynamics of the family relationships. Now, another perhaps long-term or semi-long-term trustee relationship. Maybe let's change it up with Earl and Gladys again. Let's say Earl and Gladys had 4 kids and 9 grandkids. And let's say Earl and Gladys left after they died $50,000 to each grandchild and the rest to the 4 children equally. But the grandchildren, at least some of them or many of them, were young. They were minors. So Earl and Gladys said, as to each grandchild, if they're 25 or older when Earl and Gladys die, the grandchild can have their $50,000. But if they're not 25, it's going to be in trust until they're 25. And so you're not singling a person out as far as kind of a trust. And so there's not as much kind of emotion involved. Often in those circumstances, Earl and Gladys will designate the parent of that grandchild, who is also the child of Earl and Gladys, to be the trustee for the grandchild who have not reached the age of 25 when Earl and Gladys pass away. All right, so you see the sticky one here is the temporary trustee. Not such a big deal. I know parents get hung up on not wanting to offend someone. Talk to your kids about that. The trust for the grandchildren, typically not so much. I mean, grandkids get it. They're young, and so it doesn't surprise them and doesn't hurt their feelings, I don't think, when grandparents leave things in trust for grandchildren. But the one where it's left in trust for a child, an adult child, a child who has reached the age of majority, a child who's in their 20s or 30s or 40s, and that's where it can get a little bit sticky. And so sometimes naming co-trustees is appropriate there to take the burden off of one single trustee. Now you know that if you have 2 co-trustees in Louisiana under a Louisiana trust code, unless you provide something different in the trust instrument, the 2 trustees must act together. If you have 3 or more trustees, a majority can act. What I didn't cover in this video was the corporate trustee. Some people in their trusts, they name the bank trust department or the financial institution trust department to be the trustee. And when those corporate trustees are trustees, in general, I think they do a pretty good job. But quite frankly, it's just not common. So we've seen in a lot of parents' legal documents, they set stuff up for the bank to be, or the bank trust department to be the trustee. But when the parents die, the corporate trustee looks at it and says something like, not enough money there. Not enough money to justify our corporate trustee fees. We don't want to accept that position. So you just see a lot of individual trustees and co-trustees named, but I just wanted to mention that corporate trustees are a possibility. Also, I didn't cover executors and administrators. When parents have leave their estate to their heirs through their wills, then they name executors to handle that distribution when they die. Different rules there. If there's 2 or more, or 3 or more, or 4 or 5, all of those executors must act together in settling matters related to a probate estate. So a majority doesn't control in the probate matter, at least not in Louisiana under our Louisiana probate or succession procedural rules. So be aware that that's a little bit different, that all action must be taken jointly by all of the co-executors when you're going through the probate stuff. Okay, so there you have it, your co-trustee stuff. Keep the comments coming, especially the constructive ones and especially the legible ones that are maybe proofread before you hit the send button so that I can at least understand what you're saying. Some of these comments, I don't have any idea what they're trying to ask or say in the comment because just the grammar, the spelling is just so bad. But most of it got some, starting to get some comments, kind of regularly from people, and kind of feel like I'm starting a relationship with some of you folks, even though I have no idea who you are. Okay, I'm Paul Rabelais. We'll see you tomorrow. Have a great day.